Good evening, everyone. Welcome back to another session, another episode of the weekly sessions on insolvency that we are having with Anil sir. And today we are supposed to continue the personal guarantors insolvency and personal guarantors bankruptcy. And I believe today will be the last session for the same. Over to you, Anil sir.
Thank you, Ankit. My greetings to all the participants. Welcome to episode 5 and part 4 of bankruptcy of personal guarantors under Insolvency and Bankruptcy Code. See, we have been deliberating the bankruptcy process in detail, starting with part 1, part 2, part 3, and today we would be doing part 5 of the bankruptcy process. And the most important part is kept at the end, because otherwise also as a seriatim, as a kind of seriatim of sections, it comes later. So we would be covering the avoidance transactions and also the prosecution provisions. So we have already dealt with the application for, in fact, we started with the insolvency resolution process. Then we started the bankruptcy process, which is completely a separate process. And in bankruptcy process, started with applications, claim verification, discharge, and the estate of bankrupt. And today we are now handling the avoidance transactions. So I'm sharing my screen. So give me a second. I hope it is visible, Ankit.
Very much visible, very much visible.
So this section 164 deals with undervalued transactions for individuals. As I said multiple times, that this law that we are reading, deliberating, is the law which is applicable to individuals and also would be applicable to proprietorship concerns and also partnership firms. Although it has not been notified so far, it has been notified only for personal guarantors to loan given to corporates. It may be private limited company, or limited liability partnership. If any loan is granted by an individual to any incorporated entity, and that loan goes bad, and the banks can proceed against individuals who have given guarantee to their loan. So the first process is to start the insolvency resolution process, which is a process for about 6 months as per law. But in case we add the time for admission of the application, for adjudication on the report of the RP under section 99, and also finally for approval of repayment plan, so it can be safely considered to be a process of 1 year. So after that 1 year process of insolvency resolution, then it starts the bankruptcy. So after the end, or there are other conditions, the bankruptcy process can be started in 3 months. And again, just like liquidation of companies, the bankruptcy process would start, and the almost everything like liquidation with the differences. So today we are discussing the avoidance transactions, because see, like there are many individuals, they are thinking of filing their own application under section 94 of IBC, and because they want to get full discharge from the past liabilities. So they are worried about the avoidance transactions, or what are the fraudulent transactions, where they can stack up. So all these questions can be answered today. So we would request everyone to ask more and more questions. In case, again, the format would be same, that the questions would be taken every 15-20 minutes. In case you would give questions that actually will encourage us. Section 164 deals with undervalued transactions. It's a simple section. In the what I mean to say, it's not a very long section. The transactions are crystallized as undervalued transactions. The most important part is that during the process of insolvency resolution, no application can be filed for undervalued transactions. The RP is not under obligation to find avoidance transactions. It is only the BT, Bankruptcy Trustee, in short we will call BT in this conversation. Only the BT can apply to adjudicating authority for adjudicating a transaction as undervalued transaction, and appropriate order can be sought from adjudicating authority. So the transaction application can be filed only by BT and not by RP. Look back period, unlike CIRP, in CIRP, the look back period starts. From the date of admittance of the date of commencement of CIRP. However, in the case of personal guarantors, individual insolvency and bankruptcy, the look back period starts from the date of filing of bankruptcy application. Like as we've discussed, the moratorium in the case of insolvency resolution process also starts from the day the application is filed. Similarly, in the bankruptcy process also, the look back period starts from the date of filing of the application. There is another provision in the undervalued transactions and also in the preferential transaction, that the transaction should have caused bankruptcy process to be triggered. It's a very kind of ambiguous provision. One, it says that the transaction must have been entered into this period, this much of look back period, and the second subsection says the transaction should have caused bankruptcy process to be triggered. So what can be those transactions which can be considered as a transaction which have caused bankruptcy process, which have triggered bankruptcy process? To my understanding, this will lead to a lot of litigation, and in this process, a lot of people they would be able to save themselves from undervalued transactions. But one very important condition that's not there in the CIRP. But actually, like as we started with the word associate, the definition of associate we have seen is very, very large. It covers all business associates, relatives, and that the associate, if there is any transaction by the bankrupt with any associate, that transaction would be assumed to be undervalued transactions, and an application must be filed. So any transaction which is done within the look back period with the associate, with any of the associate, that transaction would be considered as undervalued transaction, and an application will be filed before the adjudicating authority, and adjudication would be done by the adjudicating authority. However, there is an exception that the transactions in ordinary course of business is exempt. Even this part, transactions in ordinary course of business, is not exempt for the transactions with associates. So if there is any transaction with associates, those transactions, even if the transaction has taken place in the ordinary course of business, that would still be considered as undervalued transactions, and the application will be filed before the adjudicating authority. So what are the undervalued transactions? One, the bankrupt has made a gift to any person. Second, no consideration has been received from that person by the bankrupt, like there must be a property transfer, and the property includes money. If there is any property transferred, money transferred, so the consideration has not been received from the property, not been received from the party. It is in consideration of marriage. Even if the transaction is in consideration of marriage, it would still be considered as undervalued transaction. I think, in case I spend a little more time on this, see, internationally, this has been the experience that the undervalued transactions are incurred and the assets are being transferred to spouse, and it is presented in such a manner that it is given to them as a consideration of marriage. So once a person is as a bankrupt, so even if he gives that kind of anything it is in consideration of marriage, it would still be considered as undervalued transaction. Then the last is that the consideration is less than the market value. If assets transferred is having a value of 100 and it has been transferred at the consideration received is 80, so it would be considered as undervalued transaction, and the application would be filed before the adjudicating authority. Now, what kind of orders can be obtained from adjudicating authority? Number one, that the transfer, the transfer can be void. Number one. So when the transfer is void, that means it will it will become part of the estate of the bankrupt. Then the second is the asset would vest back to BT. That's again having the same meaning. Restoring the earlier status. So there are different kind of transactions, and restoring the earlier status also would be one of the order, depending upon the transaction. So these are undervalued transactions, which the look back period starts from the date of filing of the bankruptcy application. Now we can start with the preference transactions. Preference transaction or preferential transaction, section 165 deals with it. And the provisions are similar to preferential transactions under section 43 for corporate insolvency resolution process. This case also, the BT can file the application and not the RP. That's I've already explained, but there are two look back period in this case. 1 2-year look back period is for the preference given to an associate, and 6-month look back period is any preference given to any other party other than associate. So in the case of undervalued transaction, there is only one look back period, that is 2 year. Maybe the asset is transferred to anyone and the look back period is 2 year, whereas for preference transactions, the look back period has got two clauses. One is 2 years for bank associate and 6 months for other than associate. So this also has got again a clause, the transaction giving preference should have triggered bankruptcy process. This, as I said, that will lead to a lot of litigation because it is very difficult to understand which transaction, which preference transaction has triggered the bankruptcy process. It actually, the judicial pronouncements will come, then only it would be seen. So again, what are the transactions of preferential nature? That is provided in section 66. However, the what kind of orders are passed, that is provided in section 165, and it can be one option of the order passed is the adjudicating authority can declare the transaction as void, or the property transferred can even vest back to BT and form part of the bankruptcy estate, or restoring the original position. That is the kind of orders that we can seek from adjudicating authority. Now, for any transactions to be classified as preference transaction, first of all, there must be a property which has been transferred. Property includes money, funds that must be transferred to a creditor, a surety, or a guarantor. Because in case any money is transferred to any person who is not a creditor or a surety or a guarantor, that might even fall in undervalued, but it will not fall in preferential transactions. And again, the preferential transaction is the transaction must have put that person in a better position as compared to his position. As per law, protection to third party interest in property is provided if the interest was acquired in good faith. That's a separate clause, but the transaction must have put that person in a better position as compared to his position as per the law. So like section 178 provides for the waterfall arrangement for individuals, partnership firms, and for proprietorship firms. In section 178, there is a priority given to different kind of creditors. Now, in case a creditor falls at 4th priority and the bankrupt has given some or repaid some loan within the look back period to a person whose priority is lower as compared to the other creditors. that is a transaction which can be considered as, which can be classified as preferential transaction or preference transaction. So there is a clause which also provides for the protection of third party. The protection of third party interest in properties is provided if the interest was acquired in good faith, number one, for full value which has been paid by third parties. Three, without notice of nature of transaction, that also can be considered as protection to third parties. Without notice of bankruptcy application or order, so this is also so the transactions with third parties can be protected if these conditions are fulfilled, like good faith for value, without notice of the nature of transaction, without notice of bankruptcy application or order. So this is something which is so almost similar to section 43 for CIRP. Going forward, we'll have this extortionate credit transactions. Section 167 deals with it, and this is also similar to section 50 of CIRP. This is again the only BT can file an application, not the RP. RP is having no responsibility to find and report avoidance transactions. Now the look back period in this case is also 2 years, and that is also ending on the bankruptcy commencement date. So the this extortionate credit transaction is like in case within the look back period, the bankrupt has taken any credit, has taken any loan from any person where the terms and conditions are exorbitant and unconscionable, then this clause, then this section 167 would be applicable, and the order can be passed by the adjudicating authority to set aside that debt in whole or any part, change or vary the terms of the conditions, because I've seen there is a recent judgment where somebody was claiming 65% per annum interest rate, and it was considered to be an extortionate credit transaction, and the interest was reset to generally acceptable market rate. That was the order given by adjudicating authority in some other case. In the case of CIRP, ask the person to refund the extortion money. That also can be one of the order. Surrender to BT any property on which security interest is created, because the extortionate credit transaction can also be like the credit was given long back, and when this bankruptcy process was going to start, then the mortgage was given. Mortgage was given on that, on the property of the bankrupt. So this, to my understanding, can also be considered as preferential transaction, that in case you are creating a security interest. So in this case, it also can be considered as extortionate credit transaction, where the security interest is created. So the adjudicating authority can say that you surrender to BT the property on which security interest has been created. As in the case of CIRP also, this extortionate credit transaction section 167 is not applicable to regulated financial service providers. Now, in case any NBFC or any ARC or any bank gives, or any credit card company gives a loan and charge interest to the extent of say 35%, 45% per annum, so that would be considered as okay, because this section is not applicable to regulated financial service providers. Going forward, Ankit, we have finished this avoidance transactions today. I think if there is any question,
so one question,
on avoidance transaction which comes in your mind, or it is coming from the yes.
So Harvinder is asking that is it an undervalued transaction if an alimony is given to divorced wife during look back period? Now,
that's what I could understand.
Think,
it is in consideration of marriage. So the nature of undervalued transaction, it is specifically written that it is in consideration of marriage. So I can even see and confirm it is very important question. I was also not really very sure that how can this be, because on the one hand we are saying that this so when we see this we are at section 164, so we check at section 164. So
if you talk about, yeah.
It is very clearly for the purpose of this section, the bankrupt enters into an undervalued transaction with any person if he makes a gift to that person, no consideration has been received. So if it is in consideration of marriage. So the law is made in such a manner that I am only able to understand that it is in consideration of marriage. So somebody can say that since our marriage could not survive, so I'm paying this compensation. And this is, I feel that that's exactly undervalued transaction which is provided in the law.
Then Satyanarayan ji is asking if there is any time limit like in CIRP for reporting these transactions to the NCLT.
One, that I have said that it is not the responsibility of the RP to report the transaction. It is only the responsibility of the BT to report the transactions. When presently the regulations has been made, regulations for the individual insolvency resolution process and the regulations for bankruptcy has also been made. However, we have not seen any timeline during which the BT has to report these transactions. So there is no timeline. And also, I would say that in India so far, no case of bankruptcy trustee has started. No case of bankruptcy has started. All the cases are stuck up at individual insolvency resolution process only, where the repayment plans in some cases are made, or even some in hardly few cases must have been admitted for insolvency. Otherwise, most of the cases are at application stage or at section 99 report stage. So yeah, this is the present scenario. So regulations or the law doesn't say at what point of time the BT would report these transactions.
Yeah, all right, let's go forward.
Any question which comes in your mind, Ankit, regarding these undervalued transactions? Because what I'm trying to understand is, what does this mean? The transaction should have caused bankruptcy process to be triggered. This in both, in undervalued also, in preferential also. And what kind of transaction would have been like? What is the?
I think the idea behind this clause is that if somebody says that there's an undervalued transaction, so undervalued transaction would basically, we understand that it is basically sale of an asset at an undervalued value. So the idea is that the bankruptcy application was filed because the asset was sold at a lesser price than the actual market price. I believe that is what the idea is, that maybe there would have been a better chance.
Bankruptcy applications can be filed only in case there is a default.
Yeah, so that's why I'm saying that in case the asset has been sold at a cheaper price before the bankruptcy started or before the insolvency for the individual started, and because of which certain repayment plan which might have been possible in insolvency with that asset being present could not be present because the asset was already sold at an undervalued price. I believe that would be the idea that comes to my mind. That would be the most sensible meaning that I can understand out of this, out of reading this. Yeah.
Fair enough. So we can now, in case there is no question, so we can move to offenses and penalties under Chapter 7 of IBC. And we are dealing with sections 184, 185, 186, and 187. So these offenses are very important because the most important part is when the bankrupt conceals any asset, when the bankrupt hides any information or conceal any information, then there is a prosecution. So as we have seen in CIRP, the prosecution can be started only under section 236. The Section 236 of the IBC says that the prosecution can be started only by the board or if there is any other agency made by the central government. But so far it is by the board, by the IBBI. So IBBI has a prosecution department. So in case the BT or the RP finds that there are some offenses committed by either the debtor or the creditor or any other person, then the report would be submitted to IBBI under section 236, and IBBI will file this prosecution petition before the special court, which was made under the Companies Act. So I think there are about 26 special courts made under the Companies Act, and those special courts will look into these offenses and will pass appropriate order. The duties of the prosecution, that is not with the RP or the bankruptcy trustee. So I think, like when I was speaking about the avoidance transactions, I was saying that the filing of the application is the duty of BT only and not the RP. Now for this prosecution, for the offenses, even RP can report to IBBI or even BT can report to IBBI. So let us first see this section 184, which provides that the debtor or creditor provides false information to RP. So in this case, this particular section is applicable to debtor or even creditor, and the material particulars are false. Then there is a punishment to debtor or creditor up to 1 year or a fine of ₹5 lakhs or both. So this is all right. Then the second part of this section 184 says the creditor promises to vote in favor of repayment plan dishonestly by accepting any money or property from the debtor. So this is also taken cognizance, like the eventuality that has been dealt in this manner, that if a creditor says that I will vote for your repayment plan, you give me slightly more separately. So those cases are also covered, and their punishment is 2 years, and it is fine up to 3 times of the property accepted by the creditors or 5 lakhs, whichever, if not quantified, or both. So in case the repayment plan, there are 3-4 creditors, and one creditor says that, okay, I would vote for the repayment plan because I have larger voting power. However, you have to give me 30 lakhs additional or one property additional. So the penalty would be 3 times of the property and punishment for 2 years. This is also a very serious offense. Then coming to section 185, and this is on IP. That means this is on RP or the BT. And the IP contravenes provisions of this part. Now, any provisions which are contravened, there is a punishment to RP up to 6 months, and the fine is between 1 lakh to 5 lakhs. The punishment is like, I think this punishment to insolvency professional, that is strange over here. But see, like only contravening the provisions of this part. So that's the offense, and the punishment is imprisonment for 6 months. Then punishment to bankrupt for false information, concealment, etc. This is very important. Section 186 is very important. The bankrupt, if he knowingly makes a false representation, willfully omits or conceals any material information, non-disclosure of details of disposal of any property which would otherwise have been part of the estate, while making an application for bankruptcy under section 122, or while providing any information during the bankruptcy process. So when the application is filed by the bankruptcy or any response is given by the bankrupt to a bankruptcy application, whatever information he provides to the court, in case that information is knowingly false and willfully omits, conceal information, non-disclosure of the assets, then it is the punishment is 6 months and the fine is up to 5 lakhs or both. So this is the section where I say that if the debtor is not providing the information of assets, debtor is not providing the information about the income or any other material information, then the prosecution can be started under section 186, read with section 236 of the code. Section 186 further says the fraudulently, because this is again coming to the bankrupt only, if the bankrupt fraudulently has failed to provide or deliberately withheld the production of or destroyed, falsified, or altered his books of accounts, financial information, and other records. So the first was basically the concealing the assets or concealing the information. Now it is the destroying, falsifying, altering, or withheld the production of books of accounts, financial information, and other records under his custody or control. There the punishment is for 1 year or 5 lakhs of rupees fine or both. Then is the contravenes the disqualifications and restrictions imposed under section 140 and 141. I think you recall the disqualifications and restrictions to bankrupt, where I said that the restrictions are that the bankrupt is not eligible for becoming a director. He is not eligible for becoming a partner. He would not be able to enter into any transaction of more than rupees 1 lakh without even disclosing. All these restrictions, in case he contravenes and does something, he cannot even travel to foreign country. So these restrictions under section 140 and 141, restrictions and disqualification, in case he contravenes, then the punishment is 6 months or fine. Section 186 further says that if he fails to deliver the possession of any property is in the estate of the bankrupt under his possession or control, which he is required to deliver under section 156. 156 talks about the estate of the bankrupt, and 186 talks about in case he has failed to deliver, possession. These are sections which says that there will be a prosecution and the imprisonment would be up to 6 months. Then further, in case the bankrupt has failed to account for any loss incurred of any substantial part of his property comprised in the estate of the bankrupt from the date which is 12 months before the filing of the bankruptcy application without any reasonable cause or satisfactory explanation. So this is some kind of provision which is talking about some loss incurred, and he fails to account for any loss incurred. He fails to explain any loss. So this is something that we can relate to fraudulent transactions, because we have seen that as against section 43, 45, and 50, there are sections 164, 165, 166, but there is nothing corresponding to section 66, which is for fraudulent trading. And there is nothing in this bankruptcy process which is considered to be a fraudulent trading, and that can be recovered from the bankrupt. So the only thing is that in case you see this section 86 of this part of the section 86, in case he failed to account for any loss incurred of any substantial part of his property. So in case any person has actually caused any loss, so that loss he has to account for, and otherwise the punishment is for 2 years and fine up to 3 times of the value of loss, or 5 lakhs in case it is not quantifiable. Now the section 186 continues, like he has absconded or attempts to abscond after the bankruptcy commencement date. A bankrupt shall be deemed to have absconded if he leaves or attempts to leave the country without delivering the possession of any property which is required to give and deliver to the bankruptcy trustee. Then and the punishment is for 1 year or 5 lakhs of fine, or both. So in case we see this section 186, let us see that he absconding, and this absconding is covered, causing loss to is covered, and no explanation caused for the loss. He has failed to deliver any possession of the property, contravening the disqualifications and restrictions, fraudulently has failed or deliberately the production of books of account, and finally the information about the assets and other part of it. These are all regarding the bankrupt in case he does all these contraventions. So the section 186 deals with this. Section 186 deals with this entirely for the bankrupt. Now there is a serious section which is for BT, which is section 187. And the punishment to BT. In case the BT has fraudulently misapplied, retained, or accounted for any money or property comprised in the estate of the bankrupt. So any kind of misapplied, retained, or accounted for fraudulently. So that's where the bankruptcy trustee, because it's the maximum imprisonment. Like, let us see, where is the maximum imprisonment? Bankruptcy trustee is for 3 years. Bankrupt is for 1 year, 2 years, 6 months, 6 months, 1 year, 6 months, 6 months, 1 year, 2 year. When it comes to bankruptcy trustee, the imprisonment is for 3 years. See, the most important part is that the public must have faith on this profession. So therefore, these are kind of detriments which actually can keep the credibility of the profession live, because these are the kind of provisions for punishment, for imprisonment. Has willfully acted in a manner that the estate of the bankrupt has suffered any loss in consequence of breach of any duty of bankruptcy trustee in carrying out his function under section 149 to any person. So this is also like in case the BT functions in such a manner which has caused any loss. Again, the BT shall not be liable under this section if he seizes or disposes of any property which is not comprised in the estate of the bankrupt, and at that time had reasonable grounds to believe that he is entitled to seize or dispose of property. So this there is an exception that in case the BT inadvertently sells the property of somebody who is not a BT, who is not a bankrupt, and then this section may not be applicable, the prosecution may not be applicable. So this is the highest imprisonment is for the bankruptcy trustee, which is insolvency professional. So Ankit, this we finished the second part also, the offenses and prosecutions and punishments and fine under the individual insolvency, and in detail section 185, section 184 to section 87. So we have finished two parts, avoidance transactions, and we have also done the prosecution and offenses. So any questions on this, Ankit?
I think this is okay. There is the prosecution part is something that I personally feel is lagging behind in the sense that the actual execution of all these prosecutions is not really, we have not seen them happening in CARP. So it will take a while.
I think the IBBI's prosecution department is very active. We are part of the various prosecutions that we have filed, and they keep asking us the information, and they file those prosecutions to special courts.
But there are no actual, but they must be filing, but there are no actual prosecutions that have happened so far. So I think they have been all part of a process where there is no actual order where somebody has been prosecuted for all these transactions or so on.
This is also very clear that in case we see 236, section 236, when we see, then it says, the notwithstanding anything in the code of criminal procedures, offenses under this code shall be tried by a special court established under chapter 28 of the Companies Act. So the provisions of code of criminal procedure shall be applied, because if the code of criminal procedure will apply, so basically all that evidences, trial, everything will happen. So it is a long drawn process, but yes, there are provisions and it can be used. And there is a department called prosecution department in IBBI. So that department is active, and I think they have filed something like 20-30 prosecutions also.
So how I see things happening is that there are two possible ways. I think we discussed this last time also, that one, there might be a scenario where somebody is going through a bankruptcy process and that somebody has some assets left in his personal name or her personal name, and those assets are then realized by the bankruptcy trustee, sold, and certain payments are made to the creditors. This is, of course, something that might happen in 5-10% of the overall cases that will come under individual insolvency. Most cases will be the ones where there's nothing left, and it will only be a process where the bankrupt is getting a new life. And in many instances, what will happen is that the bankrupt will go through the bankruptcy process, and then maybe after 1 year, 2 years, after 5 years of completing the process, will have some amount of wealth in his or her name. I envisage that happening. So the question now is that how does the bankruptcy trustee protect himself to say that yes, there were no assets which were available with the bankruptcy trustee, because in our country those assets can be owned by his driver, those shares of a company can be owned by his servant. All these things are possible.
Yes, like ultimately, what is the objective? Objective of the law is to finally say that the person has actually become bankrupt. Now, in case you consider life of a person, the life is not about like a person will survive while the driver is owning the car or the driver is owning his house. Of course, his survival would be there, but that's not something which anyone would like to have in his life, that he is not been able to keep his own assets in his own name. He actually, that's where I feel that nobody would like to become a bankrupt till the time he is getting some major gains. But according to my understanding, like this process of insolvency resolution and also the bankruptcy, this is tilted towards the fresh start of life by humans, and it has been drafted with human angle. The maximum term in which a person can continue to be a bankrupt is only 1 year. He would get discharged after 1 year, even if the administration on and the sale of his assets is still continuing, even if the BT is still continuing, but then he would be discharged after 1 year of bankruptcy process. So my understanding is that as against the past, where the defaulters, guarantors, they were not able to do any business for 15-20 years till the time they manage, and they would suffer all kind of litigations. All that would be closed once the person decides to put a stop at one level, that yes, I have incurred some losses and I would like to restart. So let me first clear my slate and start again. The bankruptcy process is completely tilted towards individuals and to give them a new life, new commercial life. And I'm saying that everyone should use these and provisions and should not live as a defaulter. As far as the bankrupt tag is concerned, that is only restricted to 1 year, and later on it would be a fresh commercial person. So person will be able to do business. He would be considered as a direct. He would become a director. He would own assets, and this is what I feel that everyone should go for it and settle all past obligations and liabilities. So there are few other important parts which are still left, Ankit. So one issue is the under section 159, after acquired property of the bankrupt. So this section says that during bankruptcy process, if there is any property which is acquired by the bankrupt, so the bankrupt has an obligation to inform to BT within 7 days on acquisition or devolution. Now, acquisition or devolution means that the property can be acquired by any implication of law or any event, maybe that any like the will has triggered, or any inheritance has triggered. So therefore, in any devolution or any acquisition of any property, it is the duty of the bankrupt to inform BT. The bankrupt shall not dispose of any property such acquired or part with any such increase in the income with prior permission of the adjudicating authority. So he will inform the BT immediately within 7 days on acquisition. So where the bankrupt does anything as above, he is under obligation to give a notice to BT of such transaction. So these are, there is a process given in the law. So whenever any property which is acquired or devolved on the bankrupt during the process, there is a process, and the BT's responsibility is to conduct that process, and the bankrupt would not dispose of that property, and the BT would immediately take that property over, and that property would also become part of the estate of the bankrupt. Then again, there is a section 160 and section 161 which deals with the onerous properties of the bankrupt. Now there is a complete process which has been defined, and now first of all we need to understand what are onerous properties. So there are the onerous properties that I could understand is that any unprofitable contracts. Now any unprofitable contracts which the bankrupt has entered into, and there is nothing which is coming from that contract, but it is a liability at the so something which is not realizable, something which is uncertain, so, and unsellable property, not readily sellable property, and property which might give rise to a liability or a claim. So there may be some properties where the title is not clear, and the BT see that in case the BT will pursue this property, there would be an additional obligation on the estate of the bankrupt, and the additional investment would be required to clean up that title of the property. So then the BT can take a call. The BT can disclaim such properties, and whenever the BT decides to disclaim such property, then there is a complete process which is given in the law, like how to declare a property as onerous property and how to disclaim a property. There is a complete process of like giving notices to all parties, and then there are provisions regarding the other parties' consent, and also once this process is done, then those properties can be considered as the onerous properties, and the BT can disclaim the properties. So another concept is disclaimer of leaseholds, section 162. For disclaiming any leasehold interest, the BT shall give a notice to every interested party. The application can be filed before adjudicating authority for any interested party by any interested party within 14 days from the day of service of notice. So in case there are any leasehold interest available, so the BT is supposed to pay that lease rent, then the leasehold rights can be disclaimed by BT, and then the interested party, they can file an application to adjudicating authority, and the adjudicating authority shall direct under section 163 in the manner the disclaimer shall take place. So in case the adjudicating authority give directions on disclaimer, also give direction on the fixtures, improvement by tenant, and other matters arising out of the lease. So the interested party who can make an application to adjudicating authority, any person who claims and interested in the disclaimed property, any person who is under a liability in respect of the disclaimed property. In case of a dwelling house, any person in occupation or has a right to occupy. These are the interested parties to whom notice would be given before the leasehold rights are disclaimed by BT. So adjudicating authority may pass an order to deliver the property to any party after assessing the loss incurred by that person. So when we see this onerous property, and then we have seen the in case we the after required properties, onerous properties, and then disclaimer of the leasehold, and all these avoidance transactions offenses. So we have seen that. But then there are other situations that I would like to discuss for another few minutes. We have 10 more minutes, and this will be the last and final part of the bankruptcy process. I'm only discussing few important things that I feel that my audience should know about it. So the obligations under contracts, it's like section 168. Ankit, any question till now which comes in your mind? Because I will take up a few more slides and then we will close the entire bankruptcy process.
I think we can go forward.
Okay, the obligation under contracts like section 168 applicable to those contracts entered by bankrupt before the bankruptcy commencement date. So even in CIRP, when a person files a resolution plan, there are eventualities when the RA says that he would not be able to continue the obligations under the earlier contracts. So this is similar to that, the applicable to those contracts which is entered by the bankrupt before bankruptcy commencement date. So if the bankrupt has entered into any contract where he has an obligation to do something or he has an obligation to pay something, these are the obligations under a contract. Any party to contract other than bankrupt can make an application to adjudicating authority for paying for discharge of any other party or the bankrupt, paying for damages from any party or bankrupt for non-performance of the contract or otherwise. So any damages as per the order of the adjudicating authority shall be claimed as bankruptcy debt by other persons. So these are the obligations under the contract. So let us try to understand in a simple language, in case there is any contract and those contracts are somehow, it has to be like the BT would like to exit. Any party who is adversely impacted by from exit, that party can approach adjudicating authority, and adjudicating authority can even say that some damages would be payable, and even after that order, the damages that will become the debt, bankruptcy debt, and that would be paid to that person under section 178, because that would be bankruptcy debt. Now coming to the one scenario where the death of the bankrupt and continuation of the proceedings and administration of estate of deceased bankrupt. This is provided in section 169 and 170. If bankrupt dies, the bankruptcy proceedings shall continue as if he were alive. Shall continue as if he were alive. We have recently seen a application which was rejected by adjudicating authority for insolvency resolution process, saying that when a person has died, no process can be started. However, this bankruptcy process, it is very clearly said that the bankruptcy proceedings will continue. So therefore, in that particular manner, in case the resolution process cannot start, then the bankruptcy can start. All the provisions of chapter 5 shall be applicable to the estate of the deceased bankrupt. Claim of legal representatives of bankrupt shall be considered for expenses on funeral and testamentary expenditure incurred by them, and such claim shall rank equally with secured creditors. No, the legal representatives of the bankrupt. So the it is not legal here, but it is the legal representatives shall be considered. Like in case legal representatives are doing some funeral or testamentary expenditure, that actually will be considered as secured creditors. That means that actually will be considered on priority. Any surplus from the estate of deceased bankrupt shall be paid to the legal representatives. But then the legal representatives would not be liable to pay, but they would be only the estate of the bankrupt would be liable to be used for the bankruptcy debts. But the legal representatives' personal assets would not be used for payment of bankruptcy debts. Legal representatives, the only loss to them is that they would not inherit that property in case that property is used for payment of bankruptcy debts. So whenever we distribute the dividend to the creditors who has made any claim for bankruptcy debt, that is dealt with in section 174. So the BT can distribute interim dividend in case he has sufficient fund to proved debts. Notice of interim funds would be given as per regulations. Before declaring interim dividend, the BT shall make provision for, before declaring the dividend, the BT shall make provision for estimate of debt of distantly placed persons who may not have tendered their claim because of distance and sufficient time, debt not determined so far, disputed claims and proofs, expenses necessary for administration of the estate of the bankrupt. So in case BT has some money. So before the distribution, the BT's liability, BT's obligation is to keep the reserve for these 4 items. One is the estimate of debt, like distantly placed person who has not filed their claim, and that not determined so far, because there are maybe some debt which are not determined, maybe disputed, maybe contingent, disputed debts and claims, and then expenses on the administration. We also presently do in the liquidation cases, whenever we have money from the proceeds of sale of assets, we do not distribute entire while we do interim dividend. So we keep some money for liquidation cost. Distribution of property, as we say that one sections 175, any, like in the case of liquidation process also, there are reasons, like in case the property is not sellable, or property is, the BT is not able to sell the property, he can even distribute the property to the creditors. This is what it means. The distribution of property itself, not the sale proceeds. If any property is not readily or advantageously sellable, the same can be distributed in the same form to creditors with the approval of the CoC at estimated value. Substitute approval from CoC would be required for each transaction. Any person dealing with the bankrupt BT for such distribution in good faith and for value need not require if such approval has been obtained or not. So it is the approval of the CoC is only for the BT, and the third person is not really bothered whether the approval has been obtained or not. Where BT has done some transaction of distribution or sale without the approval of the CoC, then the CoC can ratify later if the transaction was done to meet some expenses of the estate of the bankrupt. CoC may not ratify the transaction if special circumstances are not found. So these are, like we've seen interim dividend, we've also seen the distribution of the property to some of the creditors with the approval of the committee of creditors. It is also provided that the CoC can later ratify the actions in case the special circumstances prevail. So when this final dividend is declared, the final dividend is provided in section 176 and regulations 33, 34, 35. So when I say regulations, this means that I'm talking about the regulations which are specific regulations for the bankruptcy of personal guarantors. So these regulations are called IBBI, Bankruptcy of Personal Guarantors Regulations. This is what is the name of the regulations. And regulation 33, 34, 35 deals with the final dividend. So the final dividend, like the realized entire estate of the bankrupt or realized so much as could be realized, the BT shall give notice that he is declaring a final dividend. No distribution of dividend can be commenced unless preliminary report is filed by the BT to adjudicating authority. This is provided in regulation 34. Bankruptcy process cost shall be deducted before any distribution. Notice shall be as per regulation, and final date of distribution shall be mentioned in the notice. Adjudicating authority may postpone the date of dividend on an application filed by any person, because this is also a kind of a process like final dividend. So on final date, the BT shall provide for all expenses of the bankruptcy process from the estate and declare and distribute the dividend to those that has been approved. So these are the provisions of final dividend, which is the way it is provided. So there is a process of declaring a final dividend, and in that application has to be submitted to adjudicating authority. So that final dividend is the kind of last chapter in the bankruptcy of individuals. There are some regulations which have been made, like regulation 27 for realization of assets. It is similar to the regulations in the liquidation process. It is suggested that the assets may be sold through an auction process. And there is again part A of schedule 2 to the regulations, as we have schedule 1 to liquidation process regulations. Similarly, there is a process for realization of assets. It's very clearly that the following person shall not purchase any asset or acquire any interest in any property of the bankrupt directly or indirectly with the permission of adjudicating authority, BT or any, in fact, without permission of BT or any partner or director of his IPE, any professional appointed in the process, any creditor or associate of the bankrupt, any company where the creditor or associate is a promoter or a director, these persons cannot purchase any property from the estate of the bankrupt. So in case the BT shall not proceed with the sale, in case he has reasons to believe that there were any collusion, these are similar provisions. The collusion provision also provided in Regulation 27 when the BT finds collusion amongst the buyers or the bankrupt or the creditors or the associates of the bankrupt or creditor, the corporate debtor or related party to the corporate debtor. So these, in case there is any collusion between any of these parties, the BT shall prepare a report to adjudicating authority and seek appropriate order. So these are then early completion provisions are there. In case there are no realizable assets, then the BT can apply for early completion. Yes, there is a provision for valuation also. Is provided in Regulation 30. The BT shall appoint a registered value for the assets owned by bankrupt. BT can also appoint a registered value for the assets which are not owned by bankrupt if he is form opinion that the valuation is necessary or when decided by CoC. A registered valuer shall do the valuation of realizable value of the asset based on the internationally accepted valuation standards based on the physical inspection. So the word is realizable value, and in the case of liquidation processes we normally say liquidation value, but it is the realizable value. So in this case the realizable value has to be calculated on the liquidation value. BT has the power to appoint an additional registered value for any asset under circumstances if deemed fit. In such cases, the average of the two valuations shall be considered. So the valuer has to be appointed as only one, but in case of any additional registered value, then the valuation would be considered the average of two. So we have already dealt with this part that even the security interest by the secured creditors, they have a choice not to surrender the asset to BT, and then the secured creditor will intimate the BT the price at which he is likely to sell. So there is a process, like in case the security interest is not relinquished in favor of the BT, then they would inform the BT at what price the asset is being sold, and BT shall attempt to find a buyer for a price which is better than the price intimated by the secured creditor. And in case the BT finds a buyer for a price higher than the price of the creditor, then asset will be sold to such buyer paying higher price. So in case the BT does not find buyer at a higher price or the buyer found does not buy the asset, then the creditor will sell the asset at least at that intimated price. Now, in case the bank says that I am selling this asset for 10 crores and the BT says that let me try, in case the BT doesn't find any person for who is giving 10 crores, then the bank will have to buy that asset or will have to sell that asset at least for that value. So any excess amount realized over the amount of the debt shall be tendered to bankruptcy trustee. So the provisions of the bank account is also very important. It is provided in Regulation 32. The BT shall open a bank account in a scheduled bank in the name of the bankrupt followed by in bankruptcy process. Like Mr. A in bankruptcy process, that is the name of the account. All realization checks, drafts, cash, etc. to be deposited in that bank account and not later than next day. This is a similar provision. Cash balance cannot be maintained. A maximum balance 10,000 rupees and payment above 5,000 rupees to be made in check. Bankruptcy process cost as fee payable to BT as per Regulation 4, payment and expenses of professionals, maybe accountant, registered valuer, advocates, and other professionals, expenses incurred in relation to the bankruptcy process, cost of realization of assets, including the cost of identification of the buyers, all expenses incurred by the BT in bringing back an asset or acquiring title to the property. I said that there are some assets where there are some contracts, there are some assets where the title is not clear, and so cleaning the title, there are some investment which can be made by the bank BT. That also will form part of the bankruptcy process cost incurred by the BT in identification of a buyer for the asset as the selling cost. So there are many books and registers which are required to be maintained by BT. So there are BT to get books of account completed within 60 days from the bankruptcy commencement date. Cash book, ledger, registers. It shall maintain separate books of account for any business that the bankrupt is maintaining. And the BT shall keep receipts for all payments. BT shall preserve a physical copy of all the registered books, reports, minutes of the meeting. Everything is required to be maintained. So these are the kind of reports which are supposed to be made by the bankruptcy trustee. One is a preliminary report, and then progress report, and asset sale report, and a final report. These 4 reports are required to be submitted by the BT to adjudicating authority. Regulation 7 provides for this. And finally, the reports, like what are the contents of these reports? Like the preliminary report is to be submitted within 90 days. It's a similar provision as we find in the liquidation process. The progress reports are supposed to be filed every quarter within 15 days. The similar provisions as the liquidation process. Asset sale report is along with the quarterly progress report. It's a similar. And the final report on the completion of the administration and distribution. These are all similar to liquidation process. The contents are also similar. Contents of preliminary report, contents of quarterly report, contents of quarterly reports are like, again, it's almost similar. What are the contents of asset sale report and the final report. And the regulation 12 says that all these persons shall extend all assistance and cooperation and in this process. The bankrupt, the creditor, employees, partners, auditors, professionals, the resolution professional, IRP, all these people will extend all the cooperation, and BT shall record and maintain the particulars of any consultation that he has had with the above persons. And this is again a section like 9 application kind of where the BT, after making reasonable effort, fails to obtain the information or cooperation from the above person, he may make an application to adjudicating authority for appropriate directions as may be necessary for the conduct of the bankruptcy process. So this is again like application as everyone is filing in CIRP that there is no cooperation. So similar application is also provided here. The mode of sale by the bankruptcy trustee is provided in Schedule 2. Step-by-step approach. Again, it is similar to the liquidation process. How to sell, what is the mode sale, fixation of reserve price, permission of this consent of the committee of creditors. So what should be the approach and how the asset would be sold. The private sales are also possible. So these are all the kind of similar provisions as we find in the liquidation process. So Ankit, this is the completion of the bankruptcy process. We have also seen summarily that how to sell the assets and what kind of reports and what kind of books and registers are required. These provisions are similar to liquidation process. But then, yes, when the bankruptcy processes will start, and these whatever I'm saying, it actually would become important. Today, there is no bankruptcy process in India, but then yes, it is going to start wherever the individual insolvency have started. Like when I talk to a client, I tell him that you should start your insolvency resolution process. He asks me the questions like, what happens next? Then I say the next will be bankruptcy. And then he should understand the bankruptcy process. Like without understanding the bankruptcy process, nobody would take a decision to file an application under Section 94. So therefore, the bankruptcy, knowledge of the bankruptcy process is very important. Knowledge of avoidance transactions, knowledge of prosecution is very important. Then only you can convince your client that application under Section 94 should be filed.
Right. So one question before we wind up, Mr. Satyanarayana is asking that if a creditor does not submit claim in case of insolvency process on personal guarantor, the security to the creditor and the security to the creditor is more than his debt. What can the RP do in that case?
So it is not a question of RP because see during the insolvency resolution process, if anyone is not submitting claims, so the repayment plan would not be made for that. It is not really important for everyone to submit claim during insolvency resolution process. It is only those people the insolvent will get discharged only from those debts who are mentioned in the repayment plan.
And the repayment plan is prepared in, of course, with the person, with the individual. So therefore, the individual kind of declares that yes, this is the debt which I have. This is the asset, corresponding asset that I have. So that repayment plan will anyways cover that asset and the debt, most probably, in most likelihood.
Yes, in case individual will say that yes, I have an asset which is mortgaged to so and so bank, and it is up to bank to file the claim, take participation in this process. However, in the bankruptcy process, it is mandatory. But in the resolution process, it is not mandatory that everyone should file their claim. But in the bankruptcy process, it is mandatory.
All right. I believe it was a good session. Thank you, everyone. We will share the topic for the next the next Sunday, and we will be back with all of you to discuss that topic.
Thank you very much. And all these videos are available on our channel, AAA Insolvency. As we always say, that the objective of these webinars is only to share and only for collective learning. So as I always say, this is our way of learning. Thank you very much. Thank you.